Hello, and welcome to Law and Democracy, a podcast of the election law program at The Ohio State University Moritz College of Law. I am Tony Gaughan. I'm a professor of law and the Kern Family Chair in Law at Drake University Law School in Des Moines, Iowa. And I'm also a senior fellow in Ohio State's election law program. I'm joined today by Professor Terri Enns, the James W. Shaughnessy Professor of Law at Moritz. Terri is also a senior fellow in the OSU election law program. Joining Terri and I is Matt Cooper, who is the assistant director for public services at the Moritz Law Library. Matt is also a senior fellow in the election law program at Ohio State. And Matt is also an associate professor of professional practice at the Ohio State University Libraries. We are joined today by Sharon Brett, an associate professor of law at the University of Kansas School of Law. Before entering academia, Sharon was the legal director at the ACLU of Kansas, where she led complex civil rights litigation in Kansas state and federal courts. She has first chaired numerous trials and argued several appeals on cases ranging from voting rights and redistricting to the Fourth Amendment to LGBTQ plus rights and more. She has also worked for the Civil Rights Division of the U.S. Department of Justice and as a staff attorney at Harvard Law School's Criminal Justice Policy Program. The topic of our podcast today is Sharon's experiences litigating election law cases. Well, I'd just like to begin by welcoming Sharon. It's a pleasure to get to interview you.
Thanks so much for having me.
Sharon, you've litigated a wide range of cases during your career. What are some of the unique aspects of litigating election law cases?
I think one of the most unique aspects that I saw in my time of practice was sort of the decision to bring something in state court versus federal court. And I think that's all the more important now as we're sort of staring down the barrel of what's going to happen to the Voting Rights Act, that there's been a lot of creativity in using state constitutional law to litigate election law claims across the country. And was fortunate to have the opportunity to do some of that when I was at the ACLU. And it's not something that I had thought a whole lot about before coming to practice in Kansas, especially when I was practicing at the federal level. I wasn't doing, or at the Department of Justice at the federal level, I wasn't doing voting rights cases. I was doing other types of civil rights cases. And really the promise of state courts in this way was something I got to explore and discover a lot more when I started doing voting rights cases in Kansas.
I teach in a legislation clinic, so we do talk about the two bites at the apple situation that you have with federal court and state court. And in fact, earlier this week, or I guess it was last week, we had two of the Ohio Supreme Court justices talking about lockstepping and how you don't, as a state court, have to apply federal court jurisprudence to the questions if they're state constitutional issues. So do you want to talk about that sort of two bites option? Did you ever have a case where you could argue seemingly even conflicting arguments because they were two different constitutions you were using?
Yeah, I haven't had a case where I was trying to make conflicting arguments within the case itself, but I certainly have had cases where we were trying to stay in state court and argue against lockstepping for exactly the reason, that you're pointing out. So the redistricting case that I handled in Kansas is a great example of that. And because of RUCHA, we really wanted to be and only could be in state court under our state constitution. We were bringing claims in that case, both for partisan gerrymandering and racial vote dilution. And the partisan gerrymandering claims are non-justiciable at the federal level. So we had to take the shot under the Kansas state constitution to try to litigate them in state court. On the racial vote dilution claim, it wasn't a racial gerrymandering claim or a VRA claim, and we were very explicit about that. It was an equal protection claim. And so we were trying to make the argument under the State Bill of Rights that the equal protection clause we have in our Kansas Constitution prohibited the type of deliberate racial vote dilution that happened in the last redistricting cycle here. And we were explicitly arguing against lockstepping there. We wanted a different test to be put in place that, we thought was much more appropriate. Didn't get the result we wanted. The Kansas Supreme Court decided to issue a holding saying they were going to lockstep on equal protection and sort of answered that question definitively in the equal protection context. But there's lots of other provisions of the Kansas Constitution for which the Kansas Supreme Court doesn't lockstep. So it was an argument worth making at the time, and unfortunately just sort of didn't go in the direction that we wanted. But yeah, the lockstepping issue is huge, right? And there's lots of incredible scholarship that's being produced right now that is trying to point out to state court judges, your text and history is quite different than the federal Constitution, and that should mean something, and you should interpret your provisions within the context of the Bill of Rights that was passed in your state and not what was just passed at the federal level. There's all sorts of differences that should be accounted for in state constitutions. So it seems like there's much more attention being paid right now to the lockstepping issue and the fact that it is an issue, right? That it's not something we should be embracing and saying needs to happen.
Sharon, could you talk about the particular facts in those cases?
Sure. So the redistricting case is sort of a great case. It's rich with facts and law and lots of different twists and turns. So that case came after the mid-decade redistricting effort. And the legislature enacted a map called Ad Astra 2. An interesting side point here is that no one actually knows who wrote this map or who drew the map originally. A bunch of maps were introduced, but no one would ever answer any questions regarding the original map drawer. So we don't even know to this day where this map came from. In any event, the map gets introduced and ultimately becomes law. And the map does a bunch of really interesting things. The first thing that it does is that it breaks up a congressional district that had previously been Wyandotte County and Johnson County together in a district. That district had been held by Sharice Davids, the only Democratic member of the entire Kansas congressional delegation. And Wyandotte County is where Kansas City, Kansas is, so just over the river into Kansas from Kansas City, Missouri. And Johnson County is just to the south of that, and it's a lot of the suburbs of Kansas City, Missouri. Those two counties had been in a district together, but because of population changes in the prior 10 years, they no longer could be completely in a single congressional district with the entirety of those two counties together. The population had just gotten too large. And so the legislature, in passing this map, decided to split Wyandotte County in half. It kept the southern half of the county with Johnson County in Sharice Davids's district. And then it moved the top part of the county, the northern part of Wyandotte County, into the second congressional district. Now, that wasn't all, because you couldn't move the northern part of Wyandotte County into the second congressional district without having to move something else out. Otherwise, that district would become a Democratic district. It contained Lawrence, where the University of Kansas is. It contained Topeka, which is the state capital. And the margins there were just too small, that you couldn't move what was a reliable Democratic voting bloc in northern Wyandotte County, a predominantly African-American and Latino population, into CD2 without having to move part of CD2 out. So what they did was they took the Big First, which is the congressional district that stretches all the way from the border of Colorado. You drive 5.5, 6 hours east along I-70, and then they came along and scooped Lawrence right on out of CD2 and stuffed it into the Big One. They drowned it in the Big One, is what we said. So this reliable Democratic stronghold, one of the most reliable Democratic strongholds in the entire state of Kansas, gets buried in the Big First, which is a reliable Republican district. And now the Republicans, in passing this map, think they have a shot at having a 4 Republican member congressional district in Kansas. So those were the facts behind the map that led us to bring litigation when I was still at the ACLU. And we brought two claims, both in state court. One was a partisan gerrymandering claim under our state constitution, and one was a racial vote dilution claim under our state constitution. So the partisan gerrymandering claim, we found support in our Bill of Rights and in our constitutional right to vote. And our vote dilution claim was just sort of a generic equal protection clause claim. So we ended up having a multi-day trial with tons of experts and testimony and hundreds of pages of exhibits before a state district court in Wyandotte County, where we got a really wonderful, strong opinion from Judge Clapper, from the district court judge there. We then immediately went to, or we didn't, we were brought immediately to the Kansas Supreme Court. So there's a procedure to bypass the Kansas Court of Appeals for these major constitutional issues. And the defendants in the case who had lost at the district court elected to use that procedure and go straight on appeal to the Kansas Supreme Court. And so I was lucky enough to do that argument, but unlucky in that the Kansas Supreme Court on a 5-4 ruling ruled against us on both claims. So the Kansas Supreme Court found that partisan gerrymandering claims were non-justiciable under the Kansas Constitution, and basically lockstepped with Rucho on that. And then had a really bizarre opinion on the racial vote dilution claim, which I'm happy to get into all the details on that as well.
Yeah, I think that would be great if you did give us a little more detail about the racial vote dilution claims. I have some other questions regarding like litigation strategy, which is kind of fascinating to me. But first, yeah, it'd be great if you went into a little more detail about that other claim and kind of how that played out.
Yeah, and it's so important to pause before I go into that, because it is such a bizarre ruling that I feel like it's divorced from everything else that happened in the litigation. And I'm still to this day confused by it. So, I mentioned before that Kansas Supreme Court in that ruling decided to lockstep on 14th Amendment jurisprudence, equal protection jurisprudence. But they also very oddly said that to make out a racial vote dilution claim under our state equal protection clause, we would needed to have met the preconditions criteria for a VRA claim. So they took a statutory requirement from Jingles factors and imported it into a state constitutional claim. And I still, to this day, don't understand how we got from A to B. I think it's just wrong on the law, right? I don't think you need to make a showing of a sufficiently compact, majority minority district to make out an equal protection clause claim. I think what we were arguing was there was intentional discrimination and diluting the voting voices of a Black and Latino community by splitting that community up in such a way that it would get drowned out. But why we would need to make a showing of the Jingles factors under the VRA is sort of beyond me. So, curious if you have any thoughts on that. If there's something I just missed here. We really wanted to stay in state Supreme Court land, and very deliberately were avoiding federal court. But we did file a cert petition to the U.S. Supreme Court on that issue to say, hey, can you please tell the Kansas Supreme Court that the VRA case law is not applicable to an equal protection claim? But they unfortunately denied our cert petition. So that's still the law of the land in Kansas. And I don't know that I'll ever understand it. But again, welcome the experts on the podcast to correct me if there's something I'm missing here.
Well, nothing that I can think of off the top of my head, but yeah, I'm curious about this. I try to keep track of a lot of election-related cases going on, around the country. But the strategy, the decisions, like whether to go state court, federal court. I mean, I know it can depend on the case and the potential claims, but I mean, state court, yeah, there do seem to be opportunities, kind of new avenues for litigation, under state constitutional provisions. But I mean, are there? I was curious to what you thought about, are there risks also? There are risks that go along with that, going that route as well. Part of me thinks, well, state high court judges, justices, they're not as fixed, I guess, as the U.S. Supreme Court. So like the composition can change, and even if you do get a negative ruling, I guess it's not the end of the world. Potentially, that you could kind of, it could come back under a different court. But yeah, I just was curious about your thoughts about sort of the risks and the promise of kind of going the state route, state court, compared to federal.
Well, I think you hit the nail on the head with the sort of risk of stare decisis being even less of a thing in state courts, especially in jurisdictions where state court judges are elected, right? So we saw that happen in North Carolina. There was a good ruling, and then there was a bad ruling as soon as the court changed. So I do think that's a risk. I don't think that it's a risk just directly inherent to state courts, right? We have seen the U.S. Supreme Court overrule itself lately quite a bit. So the sort of outer bounds of how stare decisis reigns in future decision making is an open question across the board in courts right now, I think. And I think there's many other practical considerations for bringing a case in state court versus federal court. One of the most significant ones is, how are you going to pay for it? And that's really important, right? So when you're suing in federal court for civil rights violations, there's fee shifting possibilities. If you tack on an equal protection clause claim that survives and you win, you might be able to get fee shifting under 42 U.S.C. Section 1988, right? In state courts, in a lot of jurisdictions, including in Kansas, you don't have that fee shifting possibility. So you are setting out on this very uncharted course, like we were, with the knowledge that it's going to cost hundreds of thousands of dollars in expert fees for your own experts and to defend against any experts the other side produces, because these cases are very expert dependent, and you have no possibility of recouping those fees, right? So that's a really important practical constraint. A second practical constraint that I think about all the time is that there are these incredible attorneys at these national nonprofits who are bringing these cases all across the country. And their ability to be in these courts, and particularly in state courts, which can be very parochial and insular, is entirely dependent on having qualified, competent local counsel to help them out. And that's not the case everywhere. And, in the case in Kansas, it was fun, and I got to do this case and participate in this huge trial that was so impactful, even though we ultimately lost in the end. I mean, it was a really big deal here, but I was doing it at the expense of all my other litigation that I handled at the ACLU. And I had a law office of like 2 attorneys at the time. And so I basically had to turn to my senior staff attorney and say, you're in charge of the docket. I got to do this rocket docket case for the next 3 months. Good luck. Like, let me know if there's an emergency. Because that's really what it is. We filed the case on February 14th on Valentine's Day. It was a little Valentine's Day present to Kansas. And we went through expert discovery, motions to dismiss, motions for summary judgment, a bunch of discovery disputes and third-party subpoenas. And I was threatened with an anti-SLAPP lawsuit, and we had to defend against that. I mean, it was just thing after thing after thing, to a 5-day trial, to an appeal at the highest court in 3 months. 3 months for all of that. I didn't sleep. I didn't see my kids. And literally, I did this trial as the lead local counsel. I had fantastic pro bono support. I had wonderful people working with me, and we worked with the Campaign Legal Center, who were all fantastic. But, we filed the case February 14th, and I have this like distinct memory of talking to some legislative folks the prior July, before our session starts in January. So the session hadn't even started yet. And in that July or August, the summer before, the legislative director's like, yeah, redistricting's coming, and I heard they're going to do X, Y, and Z. I heard they're going to try to get rid of Sharice Davids. And my literal response was, what's redistricting? I didn't know what, I hadn't done these cases before. I was a police practices attorney and a prison conditions attorney at the Department of Justice. And then I came to the ACLU of Kansas and had to start being a civil rights generalist. And I had to start taking on cases in a variety of different areas. And we had a very small staff, and we were the only civil rights litigation shop at the time that was capable of taking on a case like this in Kansas. And so I went from like, what is redistricting, to arguing the redistricting case before the Kansas Supreme Court in 10 months. And it's just like, we can't discount the lack of like substantive expertise in the states to take this stuff on. It's huge.
And I have a related question about the substantive expertise in the courts.
Yeah.
You know, occasionally we'll be in some conversations with someone or another, and they'll bring up specialized courts, especially during election season, when the litigation can come on fast and furiously, and it's courts that are generalist courts. Do you have thoughts about the value of a specialized court versus the general? I mean, they are applying the Constitution, which is a generalist document, but just thoughts about that?
Yeah, that's a great question. I don't know that I've ever thought of that specifically before. I mean, I think there's a whole host of things where we could make the same argument, right? That judges lack the sort of technical, scientific, specialized expertise to be evaluating the facts, right? They can certainly evaluate the law, but how do they even understand the facts? And I've had that in many cases, right? I've put on expert witnesses in policing cases that did like very detailed statistical analyses that predict the probability of a certain practice being experienced by the population again, right? And I'm not a statistics expert, and the judge is not a statistics expert. And so part of our job as attorneys is to take the highly technical knowledge that an expert might be imparting to the court and make it digestible and understandable. And, you know, I will say the district court judge in Wyandotte County, he was not an expert on voting rights cases. And he was very clear when we started this litigation and it landed on his desk that he was out of his depth to some degree, right? That he was going to work hard to keep up with us, but he was going to be learning as we did it. And that was a lot of the effort we put into the case, was making it understandable. And I talk about this a lot with my law students too, about, you know, who do we need to convince and who do we need to explain things to? Because our audience is the court, and our audience is also the public in a case like that, right? So I don't know that a specialized court with specialized knowledge even gets us all the way there where we want to be. We still have to make it digestible to the public, because they're the constituents who are going to be impacted by this case.
But Sharon, I'm interested in how you educated yourself on redistricting, such that you were then able to educate the court and the jury on it. And I'm also interested in how that may have been an advantage, or at least I would speculate that may actually have been an advantage to you, because the act of learning this fresh, I would suspect, actually then made it easier for you to communicate with people who had been in the same place you'd been just 6 or 8 months before.
Yeah, 100%. So I'll say the first thing I did was just read everything under the sun, right? I just read all the primers and the explanation materials, and like looked at the Brennan Center's materials on redistricting, and sort of just tried to absorb and digest as much as I could before the map was even introduced, right? So I did that. I was like, we're probably going to have to sue over this, because we know that there's going to be some shenanigans here. We know what their intent is. So I just tried to read and learn as much as I could. And then, you know, from the time we saw the map and put the case together, you know, the name of the game was having humility, right? So just being very willing to admit what you didn't understand and what you don't know, and
use the phone a friend option and have people teach you. So I had folks at the ACLU's Voting Rights Project on speed dial. They didn't do the case with us. They had their hands, super deep in other litigation in other states, and we were well covered with the Campaign Legal Center and Arnold and Porter, which did the case with us. And we were lucky to get Arnold and Porter to do it. They had already done the North Carolina redistricting case, so they sort of had a lot of experience, these partners that joined us. But I would phone a friend. I didn't understand something, I'd call someone. If I wasn't following, I'd make them stop and explain it to me. And I just wouldn't have any ego about it. I would be like, please make me understand what's happening here. And it ended up being a really useful tool to the litigation team as a whole, I think, because, I was like, I'm not putting on our experts at the trial. You don't want me putting on our experts. It's just going to take 20 times longer than it should to get where we need to go. I'll put on a bunch of fact witnesses, but I'm going to help you with expert prep. And what I'm going to do is I'm going to sit in the room and I'm going to say, I don't get that. What does that mean? You need to dumb it down 10 other levels because our judge isn't going to understand it. The public's not going to understand it. And then when it came time to doing a lot of the press on the case, I did that because I, at that point, had a deep enough understanding of what we were talking about on it as a technical matter, and also enough understanding of how confusing it was as a non-expert that I could distill it for the public and do press on it in a way that made sense. And I gave the closing argument too, because that's summation, right? Being able to summarize all the complex technical stuff made me an effective communicator in the closing argument. So it's sort of like knowing what you're capable of and not trying to do things based on ego.
And Sharon, could you give us examples of how you made gerrymandering understandable, the arguments you were making understandable to both the jury and to the public when you also had that public-facing role in the trial?
Yeah, I guess, one of the best examples is like Joey Chen was the expert that we retained to run simulations, right? So the question was, if you were using neutral districting criteria and you produced 1,000 maps, what are the chances that you would produce a map that looks like this if you weren't trying to game the system for partisan gain, right? So if you asked Joey Chen to explain what he does, right? He's brilliant and has this like incredible computer program that he's built to run these 1,000 simulations based on these different factors and criteria and all of that. But that's all it is. It's like, what are the probabilities, right? If we weren't trying to manipulate this map in a partisan way, what's the chance we would get a map that looks like this? And it's as simple as sort of just trying to understand what's the point of this evidence. What does this evidence actually give us? And not getting lost in the technicalities of it. So being able to sort of sum up the study that Professor Chen ran, what it showed, and what that means. That's it. And I know it sounds really simplistic when I put it like that, but that was what the public needed to know. The public needed to know, look, we've studied this from a scientific perspective, and there's no way that a map would look like this if we weren't trying to make it look like this, And I think that really resonated with folks.
I've got to ask you about switching from a trial court, from a trial to becoming an appellate lawyer. Again, that transition to me is just as hard. I've so often been told that, you can be a great trial lawyer or a great appellate lawyer, but it's really hard to do both. And you had to do both in such a short period of time. How do you manage that, just practically speaking?
Yeah, I would love to think I'm both a great trial lawyer and a great appellate lawyer. Maybe I was more of like a mediocre both. I'm not sure.
No, I'm sure you were great with both. I'm sure you.
I think it's,
and the outcome of the case and the close ruling before the Supreme Court is a pretty powerful indicator of how great you were at both levels.
Well, I appreciate that. I had a fantastic team that I worked with, and all credit goes to them for sure. I talk to my students about this too, and I teach evidence this semester. And so one of the principles that I'm constantly trying to drum into their heads is like, you have to know your audience. Am I speaking to a jury or a judge? What type of jury am I speaking to? And being able to code switch a little bit depending on your audience is really important. So, I think there's a benefit. I think it doesn't happen very often, but there is a benefit to people who handle a trial, people handling trials, doing their own appeals. You know that record cold, right? And not only do you know the record and every piece of evidence that came in, but you know what it meant in the courtroom when it came out. You know what the implication was. You know how it was influencing everybody as they were thinking about things. There's all this like nuance and sort of vibes are not the right word, but there's something that happens in the courtroom that you can't just read in a paper record. And I could really bring that into the appellate argument. I was very nervous. I had very little time to prep. It was a very high stakes argument. Everyone was watching. But I knew we were right. And I had watched every piece of testimony come in, and I knew that there was no question we were right on the facts. And I also knew that whether the court ruled in our favor was going to come down to whether they viewed the law the way that we viewed it. And all you can do on that open question of law where there's no precedent, right? There hadn't been any cases that had considered directly whether partisan gerrymandering was justiciable or not under our Kansas Constitution. All you can do is make the best arguments that you can. So we had the bite at the apple at the trial court and made the arguments. And I felt confident in them going into the appellate argument. But it's a different bench, so you never know.
Yeah, I love your point about audience. I was thinking that before you brought it up again. And I know or Terri and I have taught legal writing a number of times, and it's certainly something we would stress to our students. And yeah, I think it's incredibly important to to be aware whether it's trial, appellate level, even like clients, and there's all kinds of legal audiences. And I guess this is applicable to election cases and all other kinds of cases. But maybe that is more important in the state court route where judges aren't as used to or juries. Judges aren't as used to hearing those kinds of claims, and this may be all the more important. So kind of changing direction here a little bit, but I'm kind of curious. So in your work now, have you kind of moved on from election law? You're kind of into other things now, like voting rights and redistricting. Is that right? Do you still kind of pay attention to what's going on closely, or are you kind of moving on to other like scholarly interests or teaching interests?
I follow along on what's happening. I wouldn't say I'm as well versed as I had to be when I was actively litigating these types of claims, but I'm following what's happening in the Louisiana redistricting case and waiting for that opinion, and whether cert's going to be granted on the case that deals with whether Section 2 of the Voting Rights Act provides a private right of action. I don't think that's come out yet, right? They haven't granted cert on that one. Probably because they're waiting on Louisiana. Yeah, so if the Clay case just, blows up Section 2 altogether, then it doesn't really matter whether or not there's a private right of action. So maybe they're sort of not trying to put the cart before the horse there. But I've been following it a little bit.
What advice do you have for litigators in the future who are trying to bring claims under their state constitutions that are novel as you faced? What tips would you have for them and of course this requires having a state high court that's open. The claims haven't been made, but if you're in that position, what advice would you have for attorneys that were making those novel arguments?
I think you should look to state constitutions and state courts that have considered these types of claims already and see what parallels you can draw to the good precedent. Like, we would look at other states that had ruled partisan gerrymandering was justiciable, and we'd say, what do we have in common with that state constitution, right? Look at the history, look at the language, try to draw from those sources of precedent that are non-binding, but could be persuasive to your state court. I think because these cases are so dependent on a good factual record, or at least they were, I'll come back to that in a second, having good local counsel is just absolutely essential. So, I tell this story because I find it so funny, and in retrospect, it was maybe a little bit overboard, but I had been practicing in Kansas for a number of years. By the time I brought this case, I still hired what I called hyper-local counsel. So we were going to be in Wyandotte County, which was known for being just this very insular, parochial, sort of their own rules, their own way district court in Kansas. I had not had a case yet in Wyandotte. I had cases in many other district courts, but not in Wyandotte. And so everyone I spoke to was like, yeah, you're going to want somebody who's known to the Wyandotte judges just sitting next to you at counsel table. Like, your local counsel, you're barred in Kansas, great. That's not enough. You need Wyandotte County counsel. So I, through a bunch of connections, was able to get connected with a guy who had his whole practice in Wyandotte County District Court. And he was kind enough to sort of sign on to the briefs and appear with me the first couple times to help me look credible in the eyes of the judge, and to say, like, this is a legitimate Kansas litigator. I think that also, helped me be the one that did certain parts of the argument too. So you have to know your bench, right? I think there was an intentional decision to have me do the Kansas Supreme Court argument as a Kansas litigator instead of the partner at Arnold and Porter who had argued before the Supreme Court of the United States before. That those attorneys are fantastic, much better rural advocates than I am. But there's something powerful to having a Kansan stand up and say what you're doing to, if you approve this map, it's hurting our state, our community, the one that I live in too. So I think those were all important considerations. When I mentioned very briefly that I don't think the strong record development at the district court is as necessary anymore, I think it goes back to what I said before, that they're saying the quiet part out loud now. So we had to do this very deep factual development around whether or not they had drawn this map, whoever it is, for explicit partisan gain. That was a factual dispute in the case. In the mid-cycle redistricting that we're seeing happening now, it's explicit. They're like, oh yeah, we're redistricting now so that we can gain more seats for X party, right? It's just a different factual landscape. And many of them are doing that in places where the Supreme Court has already recognized that there isn't a justiciable claim for partisan gerrymandering under the state constitution. So they feel they can do that. But as you noted earlier, Tony, sometimes the makeup of these state Supreme Courts change. So I think it's something we're going to have to see how it plays out.
Well, I'm afraid we're out of time. I'd like to thank Sharon, Terri, and Matt for a fascinating discussion. We look forward to having Sharon on the program again in the future. Please don't forget to like and subscribe to Law and Democracy, and look for our next episode on YouTube and Apple. Thank you.